Yeah. So let's start with from the very beginning, right? You have a business idea and you need to own your business, right? I like to call this as owning a business because there are different ways of owning a particular business. The way to own a business is either you do it as a sole proprietor concern, where you are solely responsible and unlimitedly responsible for all the actions that your concern would undertake. If you uh, accumulated a debt, incurred a debt, how do you would be personally liable? Your personal assets would be involved in the scheme of things. And you have a partnership form of entity, which is a group of people, of minimum 2 people, coming together with a partnership deed. The charter document in a partnership firm is your partnership deed that governs how your business is run. Your partnership could be registered or unregistered under the Indian Partnership Act. The third type of entity is a limited liability partnership, which is a partnership, but the liability of the partners is limited. And the fourth form of an entity is a private limited company, which is the most common today. And I will come to the points to why it's most preferred today for several startups. We will also be looking at what are the benefits and advantages of being registered as a startup with the DPIIT and saying this is how you'll be registered as a startup by the Government of India. You can also get something called as an MSME registration. So we will run through all of this and say, how is it that you can effectively own your business so that your interest is protected? Now here we've listed out what are the different types of entities and what are the procedures which are involved on an ongoing basis. Let me first start out with saying what kind of entity you need to choose. It really depends on what is the type of business that you have. Let's say you have a smaller concern and you're looking to run it as a sort of a private practice of sort, right? Then you don't want to get into too much of bookkeeping, or you don't have any external person who's involved in the management of your particular company, of your entity. Then a sole proprietor concern might be beneficial. But if you're looking to have more people on board, more transparency, more corporate governance, then the LLP or a private limited company would be advisable. Now, what is the difference between a private limited company and a limited liability partnership? Now, a limited liability partnership is a partnership under the Limited Liability Partnership Act of 2008. Right? The number of compliances for an LLP is that much lesser. You have to go to the registrar of firms. You have something called as a partnership deed, which is common between an unlimited liability partnership and a limited liability partnership. You use that, you take the deed, get it registered. There's something called a designated partner in a limited liability partnership. And the actions of a designated partner it's equivalent to having a board of directors in a private limited company. However, in a limited liability partnership, the corporate governance is a lot lesser. You don't need to have any meetings under the act like you need to have in a company, a private limited company. You cannot go public. You can't fundraise in the sense of say a private equity. You can't list your LLP in a stock market. So these are all the limitations which are there. Yes, you can get foreign investment, but they will have to come in as a partner. So there will be a profit sharing. There will be all of these things which are governed. But in a private limited company, you can, while the compliances are a lot more, you need to have your tax compliance, you need to have your annual, financial filings, your accounting filings, you need to appoint your auditor, internal auditor, statutory auditor. If your turnover is exceeding a particular amount, you need to have a company secretary, appointed company secretary in the company itself. All of these compliances are there, but that is what attracts funding. Okay, let me pause here for a moment and kind of express a point of view that I've built over the last decade over my experience. Just because you raise funding, that is not a validation of your business. You could very well be running an excellent business without going through a fundraise. You could be bootstrapped, you could be revenue generating. Maybe, it really depends on what is it that you need the money for, why is it that you want to go for a fundraise, and what is so important about it. But before that, you need to first start with saying, who is going to own your business? For example, you have a trademark registration. While applying for the trademark registration, at several points we have seen that the promoter does it in their own name. They say, okay, no, the company is mine. I'm everybody in the company, so let's just get it done in my name. What happens is tomorrow when you have other parties coming into the either it's a company or an LLP, everything should be owned by the company. The promoter is a separate legal entity, and therefore we advise that companies file for registration of the trademark registration. Now, if you have an okay, let's look at the cost aspect of that. If you were a company and you were to file without an MSME registration, I think the government fee today is approximately 9,000 rupees. But if you were an MSME, if you have an MSME registration, it is cut down by half, which is the same cost as an individual owning the trademark. It is always beneficial to have the company owning everything. You have to treat the company as if it's a separate legal entity.
Goda, sorry to interrupt. There were a couple of questions from the participants in the chat. So one of them was, I think Swagata was asking about OPC as well. If we can touch upon one-person company, and Mohan had this question on what are the minimum number of people to incorporate a company. So I mean, just patching it in so that you can cover it in your presentation.
Yes. Okay, so let me then kind of get into how do you incorporate a company? What do you need to incorporate a company, right? For a private limited company, you need minimum 2 people. You would need, each of those two shareholders and 2 directors minimum, of which 1 director has to be an Indian resident. Your directors have to get something called a DIN, which is Director Identification Number. Typically, all of this can be done by either a company secretary or a chartered accountant. Both of these professionals will be able to help you incorporate your company. It would take somewhere between 30 to 45 days. They will help you with, the company will also need a PAN number, right? And your 2 directors can be the same as the 2 shareholders. Now, there is an exception to this, which is a one-person company. A one-person company is, let me put it this way. If in the long run you're looking to scale your business or you're looking to get more people into the company, a one-person company is not very advisable. Okay, you can do it. You can just have 1 person. You can have your compliances are that much lesser. Your meeting requirements are not there. But when you already have you're anyway going through the process of incorporating a private limited company, you might as well get somebody else on board. You can still be the 99% shareholder. You don't have a 90. You could have what companies do even as a wholly owned subsidiaries. They get something called a nominal shareholder. So you could have that 1 person holding 1 share in the company, just so that tomorrow, if you're looking to scale the company, you want to grow the company, a private limited company with minimum 2 people is always advisable. It just brings about a lot more transparency. It's easier. Your annual compliances are easier in 1 person company. The procedure is exactly the same. You need to have a DIN, which is a direct identification number. You need to be the shareholder. You need to infuse capital into the company. They need your ID proof, etc., to incorporate. The procedure is the same, but you'll have to convert from an OPC to a private limited company if at all you want to raise, or you want to add more people onto your company. You want further funding. You want to add another shareholders putting in money. All of that you have to undergo the process of conversion. So therefore, I think that it's better that if you're putting in the effort of getting a company, you might as well get a private limited company. Okay. So Rakesh, what was the other question?
Yeah, I think minimum number of members, should they be 2?
And also OPC, was that?
Yeah, we just covered the OPC.
Okay.
That's 1 person company.
Yeah.
Yes. So I think, do we need 2 members or has it changed recently? Mohan asked that question in a private limited company.
No, so private limited company, yes, you can have 1, but you will be a 1 person company. You will be an OPC. You can have 1 person, but you'll be an OPC. While again, just repeating myself, while you've put in the effort of going through this entire process of incorporating a company, you might as well have 2 people. Now, so this table that you see on the screen explains to you the technicalities of what is the difference between each entity. All that. I'm not going to read this out, but let me tell you what are the common questions that sort of come to me on a regular basis, and what happens with it. Okay, let's say I'll just give you an example. this one person came to me and said, I'm going to be the marketing head of this company, right? But I don't want to put in that kind of capital. I don't have that kind of cash to put in the capital. But one of the founders of that company wants me to be a co-founder along with him. But for my role, I don't have money to put in. How do I become a co-founder in this company, right? So what is the meaning of a co-founder? A co-founder is not defined under any act. It just means that you will be taking equal, to the public, you will be an equal face. But that does not mean legally you'll be taking on as much responsibility, liability. Your liability is equal to the money that you have put in. Money as in, if you put in 10%, then 10% is your liability. If you put in 5%, then 5%. You could still be a minority shareholder at 5%, but you could still have something called affirmative voting rights, which means that at 5%, you can still dictate what the rest of 95% is going to do. That is contained in your definitive agreements, which I will come to later. So if you think that, okay, you're building up, a platform, let's say, there is marketing, then there is tech, and there is something else, and you want 3 people coming together, it's not necessary that all 3 of them have to really own 33% of the company. You could still vary it depending on how much money each person is bringing in. The paid up capital the authorized capital of any company is minimum 1 lakh. Okay. So with that up to 1 lakh, that's all money. If all other money can come in as debt into the company, which is what most companies do. Now, private limited companies cannot take money from the public. This is a big default that we have seen in several startups. Starting up, you have friends and family who you borrow from and you put into the company. You can borrow in your personal name, but in the books of the company, their names cannot come. Otherwise, it is deemed to be a deposit, and compliance of the deposit rules is a completely different ballgame. Okay. Again, I'm not going into all of this because that would be very technical for you as entrepreneurs. But all that I'm saying is be mindful of the fact that you do, as a private limited company, you cannot borrow from the public. Only you as a director, at the time of you being a director, you are putting in money into the company as a loan. Okay, and then foreign ownership is something which we will also look at. You can bring in money. There are defined sectors in which you can fundraise, okay, up to 100%. There are some sensitive sectors which have, limited cap, some which require government approval, some which are just black and white, not permitted. Simple, like now, for example, recently you must have read how China's investments into India are not being allowed or are under the government approval route. So you need to go to the government, but we've seen that since April, there have been applications which are pending with the government and no approval whatsoever has been received for any Chinese investment. So you need to be mindful of the sectoral cap, but by and large, it is an open economy. Okay, except very, very select sectors, defense, agriculture, some very select sectors have caps, but by and large, it's open. Again, a lawyer would be very comfortable or would be the right person to advise you on what works for you. Okay. Now, like I said, there are a lot of benefits that come with being registered as, under the startup scheme by the government, right? Now, how do you register yourself as a startup and what are the benefits that you would be getting? Firstly, you either need to be a private limited company or a registered partnership firm. Registered firm, it cannot be unregistered, or a limited liability partnership. You should have been, so some of these changes have been made recently. Initially it used to be 5 years, but now they've extended it to 10 years. The application has to be made within 10 years. And your turnover in the financial year since incorporation should not have exceeded 100 crores. So you genuinely have to be a startup. You can't be a breakaway from an existing business. Typically, they want to encourage, under the ease of doing business policy of the government, they want to encourage you to be a startup. There are also a lot of, it's easy to get registered, to be honest. There are a lot of benefits that you will get, which I'll show you. In addition to, they give you sort of an incubator where you can, get mentorship. People can assist you on how to go about it and things like that. So these are the benefits, right? There are, again, it really depends. If you're a tech company, then some of these just don't matter. But let's say you're into manufacturing. Getting labor and environmental compliances is a pretty big deal in India, and they allow you to self-certify if you are a registered startup. Right, the labor inspector need not come and register the, to inspect the premise to ensure that you're in compliance with labor and environment laws. You can self-certify saying that you are in compliance. Now, your trademark registrations and patent filings, you do get a discount. Like I told you before, you get almost 50% discount, and it's also fast tracked. Now, if you are a company which is into, say, where this public procurement clause would apply to you, say government contracts, things like that, then your qualifying levels are reduced. Then if you want to wind up your company, because see, remember that when you are a startup, you do have a lot of compliances, and if you don't comply with that, you become liable, right? There are liabilities, personal liability, both penalties and imprisonment that is levied on the directors for non-compliance. Now, and so if you're not running the business, you might as well wind up the company or have the company struck off. Now, as a startup, if you are registered with the Government of India, you can file for voluntary winding off or striking off of the company with the ROC, and that is done in a fast track method. Okay, then you also get a tax incentive. About a year ago, there was this big issue in the market, and the entire PE community and VC community was very upset that there was tax being levied on investments in the name of angel tax. Saying if a company received an investment into the company, that was deemed to be income in the hands of the company, and that money was taxed at almost 30%. So if you received, let's say, 100 crore investment, 30 crores went out as tax. And what do you say? It didn't make sense. You're doing 100 crore on, why are you paying out 30 crores? Right. So as a startup, if you do have the registration with the government, then you do get the angel tax exemption. You get a 81AC, tax exemption. There are several benefits. These are just some which I've listed out. But on their website, you do get a lot of benefits. It's a very easy process. Just sort of go to the website. There's an online form, fill it up, and you get the registration. Now, there's a concept of MSME. There's a concept of MSME. Now, how do you register yourself as an MSME? If you're a medium or a small scale manufacturing enterprise, what is a manufacturing enterprise is, again, all of these are technicalities which I'm not really going to go into, because if you look at the act itself or talk to a lawyer, they will be able to advise you on a specific, looking at your particular business as to whether you would qualify as being an MSME or not. I personally advise a lot of my clients to get the MSME registration for the following things. Now, during COVID, there have been loans, collateral-free loans, which have been doled out by the government to a lot of startups who are registered as an MSME. The biggest advantage of being registered as an MSME is every year, all companies that owe money to an MSME have to make a filing, right, with the ROC. So there's a disclosure saying that I owe this amount of money to an MSME. So it's not that somebody can not pay you and go ahead with that, right, and carry on business. Even if there was a dispute, there is an MSME council, and that MSME council is actually very, very helpful to MSMEs. The delay penalty that they levy is somewhere close to, say, 20 to 30% interest on the unpaid amount, which is almost double to what you would get in a normal dispute process. Say you went to court for recovering a certain amount of money or arbitration, at max you would get, say, 10 or 12%, but MSME levy is almost 20 to 30%. So there are a lot of benefits that come with being registered as a MSME. Again, the MSME registration is a purely online process. They require certain documentation. If you go to their website, you just have to fill up and upload the documents that they ask you for, and you get the MSME registration. And as I told you before, you also get your trademark registration. Government fees is also reduced. So as a startup, what are the sort of initial checklist that you need to do? Ensure that you've identified what is the organization that you want, the structure that you want, what is the type of entity you want. Second, get the Startup India registration, because there are a lot of benefits that come with that. Third, do get an MSME registration, because these give you a lot of benefits that you will realize as you go on. Initially, it may look like, you know, a whole bunch of pointers, but blindly get the registrations to start off at the beginning. Okay, next, once we've looked at starting how to incorporate your business, we now go into how do you run your business? What are the key contracts that you will need? How do you protect your trademark? And finally, how do you wind up the company either under the IBC or you have the company struck off? Any company, the common notion that is there is that let's not spend any money on legal. It is not the budget head that a startup plans for. But it is extremely crucial, because people come to me at a very late stage and say, oh, but, you know, let's say, for example, we want to fundraise, but my co-founder is not on the same page. Or I put in so much effort for the last, say, 5 years or 10 years. He had orally promised that he was going to give me 10% of the company. Today, the company is valued at so much, but he's not giving me the 10% for all the effort I've put in for the last 5 or 10 years. So what happens, right? Then the second issue that happens is, you know, you either provided some service or sold some goods, but now they're not paying you for whatever reason. So then what happens? The third issue is protecting your IP, which is very, very important. I think that an NDA, the non-disclosure agreement, is the importance of an NDA increases as the value of your business increases, right? At the very beginning, let's say you have a particular product and you have a particular idea of a business. You've not really spent that kind of time or investment into developing this particular product, and you don't have an NDA signed, okay? Over a period of time, you actually build on it, you spend the time, money, effort, everything to develop this particular product. And then you have an employee who leaves with either your customer data or your code or your manufacturing trade secret, whatever it may be. At that point in time, you will understand what is the value of a confidentiality and non-disclosure agreement. Okay, so, okay. Now, what is a founder's agreement and how is it different from your articles of association? So like I told you, when you incorporate your company, the two documents that are called charter documents is your memorandum of association and articles of association, right? The memorandum is a very simple 5-clause document which talks about what is the name of your company, which state is your company registered in. That will define the state where your company is registered and will define as to which court would have jurisdiction under the insolvency code. And I will come to that, okay? So which state your company is incorporated in, what is the authorized capital of the company, meaning how much money can you put in as capital into the company, what are the objects of your company, which is very crucial because you have main objects and other objects, which defines what is the business of your company. And yeah, so this is what is there in your memorandum of association. Now, articles of association is usually when you incorporate the company, they give you, there's a standard article of association, which is a draft which is there in the Companies Act itself, where it says, 2 directors, equal voting rights, everything is equal between the two people who are there. Assuming that there are 2 people, everything is equal in the company. Now, if you want to modify that, you have something called a founder's agreement. And initially it's called a founder's agreement, and when you have further investment in the company, then it's called a shareholders agreement. Why do you need this founder's agreement? If you're okay with what's there in the articles of association, meaning everything is equal, there is no special rights. If you have put in 10% of the company and somebody else has put in 90% of the company, the person who's put in 90%, who owns 90% of the company today, can take those decisions that is permissible with 90% voting rights. Like, for example, you can wind up your company. You can sell your whole company to somebody else. You as a 10% shareholder may not want to sell it, but if the 90% shareholder decides he wants to do it, then he can. So what goes into a founder's agreement? What is it that you're looking for in a founder's agreement? Primarily decision making. That's one thing that you need to look into. Second thing is, when you say decision making, I would say corporate governance in general. Who can appoint directors? How many directors can you appoint? What are your voting rights? As a shareholder, what are your voting rights? What decisions can be taken in a shareholders meeting and what can be taken in a directors meeting, right? What are the rights that cannot be, what are the action items that cannot be done without all shareholders consent? Like I told you, say selling the business or starting a new line of business, incurring a debt of beyond a particular amount, right? All of these things are very crucial. And I would say that especially if you're not participating in day-to-day affairs of the company and you're not really aware of what's going on, you've lent your name, you put some money in, but you probably have a board seat, but you're not really in the day-to-day affairs of the company. It's very important to have a founders agreement, because all the big decisions that the company is going to take should have your approval on it. Okay. Then also other things are there in the founders agreement is, your exit right. If you want to exit the company, it depends if you're a financial investor or a strategic investor. Usually in strategic investor founder agreement, there is no exit right, because nobody's leaving. It's your own company. It just has only corporate governance clauses, right? It does not have any exit right. But if you're investing and you want an exit, like you're an angel investor, VC investor, whatever, then you'd want an exit 3, 5 or 7 years. Then the other clauses that would be there is how do you run the operations of the company, and indemnity and dispute resolution clause. Dispute clause, according to me, is more important than the rest of the agreement, because you would want to have the dispute, the seat of your, either it's an arbitration or the court, if you're going for a civil dispute, to be at a place that's comfortable to you. If you are, let's say, based out of Bangalore or South India, and you need to go all the way to Delhi to defend yourself or to sue somebody, it is added effort and a huge expense. And usually parties are not comfortable having an area that is home ground for either of the parties. They find a neutral venue. I've also noticed one thing, right? In founder agreements, I've seen people putting in a SIAC arbitration clause. SIAC is a Singapore arbitration clause. Do not put in a clause where you don't understand or you're not aware of what is the economic cost of that kind of a clause. If they say that it's a SIAC cost, they have a minimum upfront payment. And as an angel investor, you would not want to run behind a founder spending that kind of money. Or even as a founder, if tomorrow, let's say a fund were to sue you for whatever reason, you don't want to put in your own personal money in trying to litigate a SIAC arbitration, which is extremely expensive. So when you are negotiating either your founders agreement or your shareholders agreement, ensure that you understand the way it's usually said is, okay, no, we are in this together, we are partners, our interests are the same. Everything is great, but documentation is for a rainy day. On a rainy day, what is it that works for you? How much money are you willing to spend in this kind of a litigation? And therefore, the dispute resolution clause is very, very critical. Okay, so when you start your business, ensure that these are the 3 or 4 contracts which I've listed here are definitely in place. Your founders agreement. Second is your vendor and supplier contracts. Now, why is this important? One, let me just run you through what are the typical clauses that are there in a vendor or supplier agreement. Okay, first is what is the scope? Scope means what are your obligations? What is your obligation as providing the service? What is your obligation as receiving the service? What, like say, quality control, how much, what date, within how much day, from the day you place the order, how many days should they supply it, or how many days will you supply it? Will there be a purchase order? Is it a service level agreement, or is it a master services agreement? What kind of a contract is it? Right? So all of that comes under the heading scope of the contract. Then there are the payment terms. Clearly mentioned, from the date on which you've received this particular product, you will pay within 30 days, or you will receive the money within 30 days. If you don't receive it, what is the penalty clause for that? So your vendor contract is very, very critical, because today there is something called the insolvency and bankruptcy code. Now, what does this code do? If you don't pay, let's say somebody sent you a particular product, you've taken it, and oversight, you quickly sent out a text message or an email or whatever it may be, saying, I will pay you. I've received the goods and I will pay you. But you've not really looked at those goods, whether it's okay, quality is okay or not okay. You've just sent out a message saying, I'll pay you. That is called an admitted debt. It's an admitted liability. Under the insolvency code, there are grave consequences. If he goes to court, you will lose your management rights completely. There is no chance of disputing it later on. You've completely lost. They will come and take over your management, and then the company is in some sense up for buying, right? There's a resolution applicant who can come in. They can take over your company If nobody is willing to reorganize or take over your company, they will liquidate. They'll simply liquidate the company. These are grave consequences of not doing very simple things when you start off your company. Ensure that you have your contacts in place. A simple question that often comes: is a purchase order enough? Is that a good enough substitute for a supplier contract or a vendor contract? It depends. I mean, according to me, I don't think so, because you need all of these clauses cannot possibly be there in your supplier contract, right? Or at the back of your supplier contract, your terms and conditions are exhaustive. You need to say, okay, by when can I return the product? Or if you have deficient service, then what happens? Payment terms, within how much date, delay, indemnity, all of these clauses need to be there. So in a crude sense, you could say a purchase order is okay, but the terms and conditions in that purchase order need to be very elaborate. The typical, the fine print that you see at the end of each purchase order with 3 or 4 lines saying jurisdiction, particular city, amount to be paid within 30 days. That's not enough. Okay, then the third thing we're looking at is confidentiality and non-disclosure agreements. Now, confidentiality and a non-disclosure agreement, like I told you, is very important because there are many things which are trade secrets. Your customer database today, that is everything. If you're a tech company, then your tech code. Then if you're a manufacturing company, then what ingredients or process of manufacturing or whatever it may be, all of that, right? All of that forms your confidentiality, confidential information. Typically, an NDA or a confidentiality clause is contained in the employment agreement. I have seen where employment letters have been given to employees, signed by the company, but it has not been signed by the employee and given back to the company. That paper has no value. There's no point in having that piece of paper. Both parties need to sign on it. You may have an employee manual, but your agreement where the employee signs on it needs to say that I will, not only the terms of the employment letter or employment agreement or whatever it is, not only do I abide by these, but I will also abide by the employee manual. So typically your NDA should be contained either in employment agreement or a separate agreement. One other clause which is usually there in a confidentiality or non-disclosure agreement is also your non-solicitation clause, which means that you will not take other people who either are your co-workers, because as an organization you spend time training all these people. They can't take away half your team and start in a competing business. They cannot reach out to your own vendors or your customers. So that's a non-solicitation clause. The fourth other essential contract that you need to have in place is your privacy policy and terms of use. Terms of use just defines as to how you will, especially when you have an app or you have a website. This is very, very important under the Information Technology Act. Your privacy policy just talks about what do you do with personal information that you may be collecting on the website. Personal information is, your name, your address, your financial details. All of this is under the garb of personal information. What is it that you can do with it? If you are using cookies, then what is your cookies policy? How much of the data are you going to be using on? Basically, user data. What are you going to do with it? And then you say, okay, if you can either have a click wrap agreement where people select it, you have to click on it and you say, I accept these terms. Or in the terms of use, you put a clause saying, if you use my app or my website, it is deemed that you are bound by these terms of use or privacy or the privacy policy. Okay, so it's very important to have this. Otherwise, I mean, this would have all kinds of connotations. Many times, when say you're an aggregator platform, your terms of use will define that you're an aggregator and you're not actually providing the service, because the legal implications of this is very different. Just to give you an example, right? Ola and Uber are aggregators. They don't own any taxis. So if you are let's say, for example, a taxi were to get into an accident, right? Uber and Ola cannot be held responsible because the terms of use will clearly say that we are an aggregator. We don't run the taxi. They don't have the taxi license. They are not responsible for a yellow board and things like that. But your terms of use will define all of this. If you want to enroll or sign up on my platform, you need to have A, B, C, D. Or if you're a user of my platform, you agree that, say, Uber is not responsible if you enter into an accident, or the liability of Uber is restricted to X amount of rupees. So these are all things that come into the terms of use. And when you start your business, these are 4 contracts, and your vendor and supplier contracts is an ongoing requirement. Okay, then how do you protect your trademark? Often I see that, people say, okay, because of the expense involved, it's okay to not register a trademark. But trademark is as important as incorporating your company. You do that on day one. Within 3 to 5 days, you will get a sort of a temporary registration. And over a period of 1.5 years, the registry will come back with any kind of objections saying, this is okay or not okay. What are the objections you could get if you use common English words like Ola or Swiggy or Zomato or any of these Indian companies? Those are all unique words, not English words. Okay. But I'm saying, for example, let's say tree house. Those are two English words and there's no spelling change in that. Those are harder to get. Or pre-existing terms, and they will come back and raise an objection saying this mark already exists, we cannot give it to you. Now with a trademark registration, it is in about, give or take 2 years, you should get your registration. But till then, you can use it. They will want to know, since when did you start using this trademark? When is it in public domain? Things like that. It's valid for 10 years, but a trademark registration in India is only valid in India. If you have a trademark registration outside of India, unless that product is so popular that it is known in India, let's say, I'm just giving you an example. Let's say, an Apple product. They may or may not have, Apple does not sell directly in India until recently, but their product is known world over. That today, if you want to get into the section of, making computer goods or electronic goods with the brand name of Apple, then they will not give you the registration for that. Typically, if there is a trademark violation, what do? You have to go to a court to get an injunction, which is a temporary. They will give you a temporary injunction, and civil suits in India take somewhere between, say, 2 to 5 years. And at the end of it, once the court decides whether there's actually infringement or not, then it will decide either in your favor or against you. Okay. Then we come to the winding up procedure. Just before that, let me pause here and tell you what are all the compliances that are typically required. Okay. But this being said, do understand that most of this is actually done by your lawyers, your company secretary, and chartered accountants. Your books of accounts are maintained by your accountant, who is very important. And your routine, like every quarter, you need to hold a board meeting. Every year, you need to have an annual general meeting. At the minutes of the meeting needs to be filed with the ROC. If you are, say, pledging your shares or you are creating a charge in any of your assets, that needs to be informed to the Ministry of Corporate Affairs. So all of these procedures needs to be done on a timely basis. If not, there are penalties for all of this. Now, when you start a particular business, there are registrations, legal compliances which are required under each act. Each state has a Shops and Establishments Act. You need to get registration under that. If you are a fintech company, there are RBI registrations or licenses that you need. So all of this, your lawyer will be able to advise you based purely on which sector or which industry your business is based out of. All of these compliance, as so long as your company is up and running, you need to ensure that these compliances are in place. Financial, secretarial, and legal compliances have to be in place. Most cases, the directors are responsible for any non-compliance. So, over a period of time, when you realize that you are either the company is not doing well enough and is unable to pay off its debts, or there is no business at all for the last 2 years or more, and you want to wind up the company. Now, how do we do that? Under the Insolvency and Bankruptcy Code, you need to make an application to the National Company Law Tribunal. This is where I told you the registered office of the company comes into play. Whichever state that you're registered in, that particular bench of the NCLT will have jurisdiction. It's easier for you to file there, right? But then again, people do register or incorporate companies in different states for tax purposes, because let's say you're a manufacturing company. If you are registered in a particular, some states are more tax efficient compared to other states, and therefore they incorporate in those, or let's say there's a SEZ benefit or whatever it may be that you may be getting, they do incorporate companies in other states. Just because you incorporate in a particular state doesn't mean you can't run business in other states. You very well can. Okay, so how do we, under the Insolvency Code, you file an application saying that either as a voluntary winding up, which is basically under Section 10, you say that I'm not able to pay my debts, and therefore, either put my company up for sale, which is called restructuring of the company. right? Your company is up for sale. Somebody can infuse company and buy over your company, or the company is liquidated and struck off, basically. There is another process. If you do not want to go to court, under the Companies Act, you can get the company's name struck off from the register. You need to ensure that after you incorporated your company, you haven't carried on any business for the last 1 year, or for the immediate 2 preceding financial years, there has been no business whatsoever. You file this application. Again, the process or the nitty-gritties of this will be your company secretary or your chartered accountant or your lawyer will be able to advise you on how to go ahead and have this done. Now we come to fundraising, okay, which is pretty, what do you say? Some sense a note, indication that your company has come of age or is there, right? There are several kinds of ways in which you can raise funding. One is equity, where you give equity of your company, ownership of your company. Debt is where you can do, it's like borrowing money, but it's just not from a bank because the targets are that much higher in collateral, etc. So they do offer, you can offer instruments like optional, OCD is optionally convertible debentures, and CCD is compulsorily convertible debentures. CCD is where over a period of time, the debt is there, there's interest running, and on that amount, it converts into equity. When you say convertible, it converts into equity. Then what are the different stages in equity fundraise? What are the documents and what are the key clauses, right? Now, typically when you want to say, go in for a fundraise, I usually advise my clients that you start doing your internal cleanup diligence, okay? You do a legal diligence where the lawyer and your accountant will handle the financial, the lawyer will handle the diligence. We look after it, we do an internal cleanup process. We check everything, based on the company. We look at all the registrations that are required, licenses, contracts are in place. We sort of do a cleanup of the company and bring it up to speed where an investor looks into it and says, okay, this company has, decent at a series A or a pre-series, they don't expect a high level of corporate governance, but to some extent, it's not like you're carrying on a manufacturing activity without a fundamental license, or you're a fintech company without RBI approval. Those are very, very fundamental, and trying to fix that is a very difficult and a long drawn process. It puts off investors. They say, okay, he didn't even take care of such a fundamental thing. So usually you prepare something called an information memorandum. Incubators do help you out, bankers do help you out. There are several people in the startup ecosystem who help you prepare information memorandum, which tells the investor that this is what our company does. This is our, this is how much we've been growing. This is our revenue. This is our market share. Typically, fundraising happens at that stage, right? Where you realize that year on year, you are increasing at almost 100% rate. Your revenue is that much more. Market share is doubling, right? So that usually comes in, say, the 2nd to 4th or 5th year is what we've usually seen. And fundraisers usually happen around that time. Why you want to fundraise is something very, very personal to each promoter. And if you have convinced yourself that you really need this money, not just for validation, but actually need it for running your business, then you'll be able to convince an investor that much more. Once they are convinced, they send you something called a term sheet. Typically, term sheets are called non-binding, but just because it's called non-binding, it is non-binding. Legally, yes. But once you sign it, the term sheet is will exactly reflect in your shareholders agreement. Shareholders agreement, they'll say, listen, you signed the term sheet, now you cannot back out. I have interacted with several promoters who have this notion that don't get lawyers involved at the time of a term sheet because it would derail the transaction, to be honest, right? But that's not true, because there are several legal clauses, like how many board seats, what are affirmative voting rights, what is the exit right, how much IRR is the investor expecting, what are the indemnity clause, what is your event of default clause. All these clauses come up in the term sheet, and only a lawyer is able to help you with all of these things. Explain it at least to the promoter, saying this is what this would mean, this is what this clause would mean, and therefore you need to look into this. Right? So a term sheet is non-binding. It will broadly tell you what is the money that the investor wants to put in, whether single tranche, multiple tranches, over how much, when do they expect an exit? Typically 3, 5, or 7 years they expect an exit. Whether it's going to be a foreign investment, usually funds put in money through an overseas entity. So therefore you will have all your FEMA compliances. you look at a term sheet and you will be looking at, like I said, your corporate governance rights, your event of default, meaning what constitutes an event of, when does an event of default trigger? When is it that you have defaulted, right? What happens if you have defaulted? Typically you have to give an exit, right? What are the ways of giving an exit? What happens if you don't give an exit? If you don't give an exit, there is usually a buyback clause, means as a company you have to buy back the shares of the investor, or there'll be a put option, meaning that the investor can put the shares and you have to purchase the shares from the investor. Now we then look at, there is a drag option. If you're not able to provide the exit, they can drag the shares of the promoter and sell it to any third party. Basically, you're losing the company because you can't give them the exit at a particular time. Exit price is also mentioned in your term sheet. What is the price at which they are expecting? Typically, the 2x, 3x MOIC, or 12% IRR, 20% IRR, whatever. These are, it really depends on sector to sector, what is the amount they're looking at. And that is what is contained in the term sheet. Once you get the term sheet, after it's signed, there are two important diligences. There are others which the investor would do depending on what they want, but typically it's your legal and financial diligence. They will want to see all your charter documents, your memorandum, articles. What is the, in your books of accounts, what is the loan that you have? Do you have all your licenses in place? Do you have, any litigation that is pending? What are your assets? Title document to your assets. Do you own this real estate? Or is it on rent? If it's on rent, what is the agreement you have with the landlord? For how long is it valid for, etc., etc. So all of these things come into play in a legal diligence. Financial diligence is typically, how much cash flow, who are your customers, etc., etc. Okay, then once you've signed your term sheet, the next document that comes into is your share subscription agreement. Under share subscription agreement is where you issue the shares. For example, say for 10% or 20% of the company, you're allotting shares. The process of allotment, how do you allot the shares? Within how much time should the shares be allotted? What are the conditions precedent? Now in your diligence, what happens? They'll come up with 4 or 5 things which you should have done but you've not done. But they're not deal breakers, but ideally they want you to catch up, come up to speed with the corporate governance requirements for them. So those come as condition precedent. They'll sign the SSA and the SHA, but they won't put in money till you finish your condition precedent. What are these conditions precedent? Like I said, you don't have contracts with your employees, for example. They would want all your contracts to be in place. They want the NDAs to be in place. So these are all the typical clauses that come as a CP in your share subscription agreement. Within how much time should you allot the shares? What are the reporting requirements under FEMA? So again, all of the reporting requirements, all of that between your lawyer and the company secretary, these compliances will be looked after. But negotiating the terms of the share subscription agreement, how many tranches, all of that is done between the lawyer and the promoter. Then the other definitive agreement is the shareholders agreement. This comprises, like I told you, it comprises of all the clauses in your founder agreement. But shareholders agreement isn't invested in place. Typically, an investor will want an affirmative voting right. Certain decisions cannot be taken without the investor being present at that meeting. Second requirement, they have to give you their approval. Without their approval, you cannot do it. Even if they have just 10% investment in the company and you have 90%, you cannot take decisions without their approval. You would be in breach of the shareholders agreement. Which is why you need to, you can't just look at commercials of the deal and say, okay, this is the money they're putting in for this amount. Just because you're putting in that kind of company, that kind of money, how much of your company are you willing to give up to them in terms of rights of the company? Then there are governance rights, then there are information rights. Let's say, for example, today an investor is putting in 20%. If you don't have something called a fall away clause in your shareholders agreement, after subsequent rounds of funding, it will take a lot of time, but from 20%, it comes down to, let's say, below 10%. But all of these rights are still there for him. It would be a huge compliance requirement for you to go to a shareholder who has less than 10%, let's say 5-6%, to get his approval for big decisions, right? So there's something called a fall away clause saying if you go below the 10% mark or the 5% mark, all of these preferential rights fall away. Typically, what we do is investors don't take equity shares. They take something called a CCPS, compulsorily convertible preference shares. Okay. Now, CCPS is a basic preference share that they get preferential right in the sense of dividend, or if you're winding up the company, whatever liquidation money you're able to recover, they get preferential rights in that. But other than that, everything else has to be agreed upon in the shareholders agreement. The law does not give them any kind of upper hand in the upper hand in board rights, or upper hand in day-to-day management of the company, or voting rights, or any of these things. It needs to be contained in the shareholders agreement. What happens, there is also a clause called the good lever or the bad lever. If you as a promoter, let's say are siphoning of money, or there is some kind of a fraud in the company, right? What the investors have, the clause which is contained in the shareholders agreement is called a investor lock-in, vesting rights, or a clawback clause. You as a promoter may own 90 or 80% of the company, but those shares don't belong to you. The economic right in that particular share belongs to the investor. They have a right over those shares. You will have to claw back your rights to those shares over a period of, let's say, 3 years or 5 years. It depends on how long that investor is invested in the company and how long you've been in this company, how many rounds of funding have you done before, all of these things. So when you look at a shareholders agreement, it needs to be looked at holistically. And that's why I say these clauses don't really usually come up in the term sheet stage, but you have to expect that, well, if I want to take on an investor at 3% or 4% and give them all of these rights, right? So you need to look at the documentation holistically and not purely from a commercial point of view. I've listed out what are the typical clauses in a shareholders agreement, and you can just go look through it. We've touched upon most of these things. And yeah, so that kind of brings me to the end of the presentation, and I'm happy to answer questions at the end of the breakout session. Before we go to the breakout rooms, I think Ananya has already shared a term sheet, right? Now, what we thought we'll do is, you received it by mail. You can look at the term sheet and go through it, and let us do a sort of a mock negotiation of sorts. As a promoter, if this was a term sheet that was given to you as an investor, which clause, according to you, in the term sheet is a deal breaker? Okay, that's all that I want to know. According to you, there's no right or wrong answer to this, to be honest, because it's very individual. But just so that you get a feeling of what works. It's okay as a promoter for you to put your foot down and say, no, listen, I'm not okay with this kind of a clause. I'll probably wait. I'll get some other investor. Wait for another 6 months. My revenue is going to increase, or my business is going to grow. So let's look at. Let's go through the breakout room, and let us come back, by which time I'd like to hear your thoughts on what clause does not work for you in this term sheet.
We get started with some of the questions that we were having in our group. I think it was quite comprehensive, the term sheet. Thanks for that, Goda. And we actually got a very good taster of what it means to receive investment from an investor, and what are the kind of terms and conditions that they might have on you. I think the first question that we were negotiating on, or where we felt that there is an opportunity to negotiate, is in terms of the exit rights. Basically, the investors, there's some
दो आप लोग स्टार्ट करो अपनी पार्टी ना.
Okay, yeah, all right. So I think the exit rights is a clause where I felt that we could negotiate, because the investor is asking a price higher than the fair market value, or 3 times the amount that has been invested in the company. So as a startup founder, once I've kind of given my equity for the money, why should I assure you that kind of an exit 3 years? I think they are saying that if they don't receive an exit through another investor, I have to, as a startup founder, give the investor 3 times exit. So this is unfair, because it's not debt where I'm liable to give any exit. So I feel that this is one clause where we would kind of negotiate. And in terms of board representation, I think one of our team members, Tripta, had a concern that how about, if you have like too many advisors from their side, then it will change the direction of the company. So we have to negotiate there. So these were like a couple of things, and there were a few other aspects, but I'm just bringing up the top concerns. I mean, there was one concern by Pragati on confidentiality, which I think was discussed, but if she feels it has not been addressed, she can also ask the question. Yeah. So any observations on that, Goda? How is our thinking right, or is there a way that we can negotiate with the investors on that, or it's a standard clause given by the investors? How do we react
Yeah.
to that?
So let me just hear everybody's concerns, so then I'll tell you finally actually how it works.
Okay, sure.
What are the other, do any of you have any other concerns as to what would be the deal breaker clause? Why would you not sign this term sheet according to you?
Yeah, I think Atharv and Abhishek. Okay, yeah. So let's go in order. Atharv, you can start, then Abhishek, then Swagata. Yeah.
Yeah, so I was just wondering if addition of clause will be entertained.
Like what? Yeah, sure, whatever. Yeah, I mean, it's as a term sheet is up for negotiation. You can add, delete. You can tell them, I will send you a fresh term sheet. You can do whatever you want. It's a negotiation table. It's about how much you want the money.
As part of board representation, it's written XYZ will also have the right to appoint independent advisors to the board. However, there's no restriction on the number of advisors that is applicable or is possible, which will eventually, even if there are people from our side with 2 voting rights and them with 1, if the advisors overpower them, it is usually their side which prevails, right?
How does an advisor overpower any vote? I mean, it's 3. I mean, just say 2:1. How does an advisor is just non-voting? Advisor will just tell you, like for advisor would typically mean, like say let's say for example you are discussing a financial point of view, say an accounting thing. You want a chartered accountant to be able to look at it. There's no point in a director can't possibly know everything, right? They just put their person over there, but he wouldn't know. So let's say, for example, they want somebody from the Big Four or PwC or EY or somebody from there to attend the board meetings because there are some major financial decisions to be taken. How does a observer or an advisor change the course of the negotiation? Anyway, it's fine. Again, nothing right or wrong in what you've said. It's your concern, which is fair enough. But then again, this is a very standard clause, and it doesn't really get deleted or is not a very negotiated clause. Yeah. Okay. Any other thing that? Yeah.
I think Abhishek, did you have?
Yeah, I had a couple. Under the no shop section, it says the founder will not agree to solicit any other offer. From whatever I've seen in business or whatever, you see multiple bidders for a company, or like in the private equity space or whatever. There are multiple players who bid at the same time for the same company. So the company, I think, does have the right and the jurisdiction to choose who they want.
But Abhishek, I'll tell you one thing. I am an investor. I have given you a term sheet, and you have signed the term sheet. Okay. Now I have hired my lawyers. I have hired my investors. I have told my LPs who are investing in my fund that, listen, we've got a signed term sheet and we are incurring expenses, huge expenses. This is huge as in say 20-30 lakhs would be the diligence cost. Okay. It's not just some money. I gave you a term sheet. You've signed it. Let's say you take my signed term sheet, you go to the market and say, listen, this fellow is willing to give me, X amount of rupees for this percentage. Does somebody else want to get the, I mean, it's sort of an auction process. What does that reflect on the promoter? Firstly, that about your commitment. Okay. Firstly. Secondly, I as an investor would want a sort of exclusivity till the time we at least finish this deal, right? Because you signed the term sheet.
So maybe a additional clause could be added saying that if and when the term sheet is signed, then there can be exclusivity where you can't. But I I feel that before signing the term sheet saying that, okay, you can't go and solicit any offer.
No. All these clauses are, when you sign only, this term sheet comes into effect. Not no.
Acha.
Just
And
sign term sheet only you get. That's why I'm asking, will you sign this term sheet? Is my question.
you brought up a valid counterpoint, so I don't have an answer right now to that. But also another thing that's a cause of concern is that under the ESOP, you've said that the 6% that the employees have an option to is non-dilutive to XYZ. But I don't think that's fair to the founder, in the sense that because any additional capital that's raised is dilutive to across all the
I, as
shareholders.
an investor, don't want to run your company before or take on any liabilities of the company before I put the money in. I don't want to. For me, you should have provision for enough senior management or enough attractive packages to get senior folks into your company already. Technically you should have put in your ESOP in place on day one. Today, I don't want to dilute. I'm putting in money because the value of the company has to grow. As an investor, if I put in money and you're going to take those shares, so effectively, what's happening is I'm putting in, say, 3 crores for 10% of the company, but actually I'm getting only 10% minus 6%. Why should I put the money and dilute? Because we came at a valuation based on the entire thing.
Correct.
The entire value of the company. Today you're asking me to put money and ask me to dilute. It's like taking from my left hand and giving back to the right hand. No, but again, no, there's no right and wrong. This is exactly what investors say, and this is exactly what promoters also say. So what we do is usually we say, this is a negotiated clause. 6% is a very high ask. Usually 3 to 4% is okay. Sign.
Acha. And is it all right for like the investor to ask that in any other subsidiaries of the XYZ that
So what we do is for the subsidiaries, we say only if there is control of that company. Meaning if the subsidiary as in we have more than 50% obviously of the company, and we actually have control of that company. You may have shares, but if you don't have control of the company, then what? You as a promoter, what will you give the investor? So unless you have control of the company, then it's okay. But again, negotiated. Sometimes we take the clause out also.
all right.
And Swagata had a question, I guess.
No, so this particular clause under founder lock-in and vesting, where it says that as long as XYZ is holding any share, the founder may not transfer, encumber, or dispose his part of his shares, right? Which is, I think, 70% of the shares without approval. Is that something that is okay, or?
If I am putting money into your company, and then you sell your shares and go off to some other company.
No, but can it not be with a like more than 5% shares, or more than? I mean, there could be some discretion given to the founder as well, right? More than X%.
As in, if you are selling more than 5%, I should be okay with it.
Yes.
You should come to me for approval.
Yes.
But tell me one thing, I'm putting money into your company because I believe in you. I want you to run the company. Why would you? So what happens is this conversation usually ends up on trust. Okay, I'm believing you as a founder. Are you telling me that it is possible that you will sell more than 10% of the company?
No, I may not sell more than 10%. I mean, that is significant, but maybe up to 5% I can.
We usually do keep that 5% only for liquidity. Up to 5% is okay with investors. They'll say okay, but anything beyond that, they will want. They'll have a ROFR, which is right of first refusal. You have to sell to them first.
Okay. And quickly, anyone else who would like
and
to?
Expenses also.
Yes,
the last
you
part.
can continue. Yeah.
Yeah, the expenses of company will bear all the legal accounting incurred by
clause usually. Very, very negotiated clause. Bigger funds do not absorb. Bigger funds do absorb costs because they have the like Sequoia and all. They absorb costs, but the smaller mid-sized funds don't absorb costs.
Okay. Dr. Murthy, you had.
Hello.
Yeah, we can hear you. Yeah.
Hi, Goda Raghavan. It was an excellent, fantastic talk. It was awesome. That's what I would like to describe. Yeah, I went through this term sheet. There were many doubts. I mean, to my knowledge, at many points. See, there is a pre-money valuation that has been done at INR 3 billion. Now, how does that happen? When XYZ is investing 3, this is pre-money is before probably the company gets valuated. I mean, probably I don't know. This is a ABC company, and even the directors, existing directors.
No. So pre-money valuation just means what is the valuation of the company before they invest the money. That's all.
Yeah, that pre-money valuation is this fine? INR 3 billion?
Yeah.
Okay.
Startups are valued at equally whatever money.
Okay, and I had an objection also with the exit right. I mean, exit policy. Okay. Wherein the 3x, I mean, that was definitely not acceptable. And another
Actually, to be honest, the term sheet was not signed because of the 3x.
and there was another objection.
The promoter said that is too much. You give me IRR at around 12% or 10%, then okay. But at the 3x more, so we are expecting.
Yeah.
Like I mean, I might as well get a loan from a company. I mean, from a bank.
And there is also a governing law and dispute resolution at Delhi jurisdiction. My company is owned in Bangalore. Why should I run up to Delhi? I would like to have everything in Bangalore. Even that one is enough.
Very valid observations. Correct.
So that is 3 things which I could observe to my knowledge.
Yeah.
Great.
Yeah, I think my question also was on the exit rights as well. It seemed like, as you rightly said, I'd rather take a loan than promise a 3 times exit. Then what's the whole point of equity in the first place?
But again, let me tell you, this is not an uncommon clause at all. It's just that company, that promoter is not okay with it, and whatever. There are many reasons, not just that you're not okay with it, because it really depends on your company when you're fundraising, how much you need that money. If you're raising the money only because you want better valuation, it's a different ballgame. But sometimes money which are cash burning, FMCG don't need that money.
Yes.
They need marketing. They have our marketing expenses. They can't grow if you don't. It's like a chicken and egg sort of situation.
Yes.
And one more thing I would like to ask. I mean, this especially the exit price is applicable only if I'm exiting within the vesting period or after the vesting period.
Has it?
No, the vesting, basically the vesting period of 36 months. Yeah, is it applicable only?
Yeah, so that term sheet does not have a follow-away clause saying that in case I give you the exit at 3x MOIC, but you don't take it, then that clause has to follow it.
Okay. Okay, fine.
Yeah, so I'll have one question
Thank you.
for you, Goda. Thanks, Dr. Murthy. So one question would be, what is that one clause that you wouldn't have opted for, or you wouldn't have signed this term sheet for?
The MOIC.
Okay. The exit one. Okay. Yes. So we are in line with your thought process.
No, but it really depends. Like I said, that's my take on it. But it really depends on what my business would be and how much I need that money.
Correct. Yeah. So I think there were a couple of questions during the presentation itself. I'll just bring that back in, so that we can have them answered. So one question was from Mohan Kilariwal. So I think while your presentation was going on, he asked, does it include government agencies as a buyer as well? Section 15 of the MSME Act, liability of buyer to. Okay. And Pragati Agarwal had another question. She says, are startup board certification and DIPP certification different? Okay. It's the same, you're saying? Okay. Yeah. Okay. Any other questions from the participants?
I have a question on the what does put option against the founder mean in the exit right?
Yes.
put against the founder means that the investor, if you don't provide the exit, put means I'm going to put my shares and you have to purchase my shares. So the investor will put his put option notice, and either the company or the founder has to buy the shares out. Put against the founder as a personal liability, which maybe 5 years ago or 8 years ago was okay to sign that clause, but in today's startup ecosystem, no founder takes that personal obligation. The put is usually against the company, which effectively means a buyback.
Okay.
When a company is buying its shares, it means it's a buyback, it's a capital reduction. And
but at what valuation it is? I mean,
if it's a foreign invested company, then it is at FMV. It can't be higher than FMV.
What is FMV?
But if it is a domestic investment, then it can be at whatever pre-agreed price.
I think fair market value. FMV.
Okay. Okay.
Yeah.
Okay. Yeah. Okay. Okay. Yeah, I think. Yeah, Rima had a question. Yes.
Okay. Actually, I just want to confirm that this term sheet is not the standard term sheet. It can be vary according to the requirement of investor company and mutual agreement or the mutual consent of both the parties. Is it so?
Yes, very much.
Okay, thank you. But what are the key terms which are standard?
And nothing is standard. To be honest, nothing is standard.
Okay.
Because it really depends on, like I said, it depends on how much you want the money, and your attitude with the investor dictates the term sheet. To be honest, like investor lock, if a promoter lock-in is fair enough. I mean, even if I were representing the promoter, I would say it's fair. If I was representing the investor, I would say definitely I'm not letting the promoter go till the time I'm invested in the company, because you're putting your money only because of the promoter.
Exactly.
Yeah.
But the dispute resolution is very important for any term sheet, I guess.
Yeah. So it really depends. The investor senses it. When we realize that the promoter wants the money, then the investors go the investor goes very, hard on the promoter.
Yeah.
But when the investor says, listen, a promoter says, okay, money is good, but even if you don't give it, it's fine. I don't really need this money. I'm not yearning for it. Then the investor's attitude changes.
Yeah. So there is always negotiation between both the parties for term sheet as well.
Yeah.
Okay. Thank you.
No doubt about it.
Thank you. I think Rima comes from this background of IP and technology transfer. So she's part of the IIT Delhi Technology Transfer Office. So I think her observations come from that as also.
Excuse me, Dr. Murthy here again.
Yeah.
To Goda ma'am, just I wanted your view on this founder lock-in and vesting.
Has it? What
I mean, especially in this term sheet.
No, founders lock-in is very, very common. This clawback is also very common. Sometimes there's a clawback clause. Sometimes they'll just say, listen, for 3 years, you can't transfer to him. That's all.
Is there a clawback clause here?
No, there's no clawback clause. They just want the founder to be locked in. That's it. You cannot sell your shares.
I had a question in the term sheet about in the founder lock-in only about the 7. I just wanted to confirm, does the 70% of the shares held by the founder mean that if the founder owns 90%, 70% of the 90 is kept as reserve and is vested over that 3 years, but 30% of the remaining 90, so 21%, 27% is what he currently has already. Is it that?
Correct. So up to 30% he can transfer without investor approval. 70% is locked in for 3 years.
All right.